Hello and welcome to Courts Today by Live Law. Let us get to today's top legal updates. The Supreme Court has granted custody parole to Delhi riots accused Tahir Hussain for Delhi Assembly elections campaigning. Kuki Organisation has sought early hearing of a plea in the Supreme Court for probe against Manipur Chief Minister over audio clips. News Broadcasting Digital Standards Authority has rapped News18 India and anchor Rubika for suggesting Arvind Kejriwal is guilty in the liquor scam case and directed to delete the broadcast segment. Saying that BNSS provisions are adequate, the union government has turned down Supreme Court's suggestion for a separate law on bail. A Delhi court has ordered FIR against journalist Rana Ayyub for allegedly insulting Hindu deities, spreading anti-India sentiment on social media. The Telangana High Court has temporarily restricted children's entry into movie theatres after 11 p.m. and directed the state to regulate the entry. And in the Adani-Hindenburg matter, the Supreme Court has affirmed registry's refusal to accept plea to direct SEBI to complete the investigation in the matter. I am your host Urvashi Chauhan with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Please make sure to watch this video till the end and do not forget to like, share and subscribe to our channel because your support means the world to us. The Supreme Court has today granted custody parole to Mohammad Tahir Hussain to canvass votes in the Mustafabad constituency as a candidate of the AIMIM in the elections to Delhi Legislative Assembly. Hussain had moved the court seeking interim relief in the case related to the murder of IB officer Ankit Sharma during the 2020 Northeast Delhi riots. However, today he restricted his prayers to custody parole, given he is in custody in a few other cases and there is little time left for canvassing. A bench of Justices Vikram Nath, Sanjay Karol and Sandeep Mehta passed the order today after the bench of Justices Pankaj Mittal and Ehsanuddin Amanullah had delivered a split verdict last week. As per the custody parole, he will be released during the day for 12 hours from 29 January to 3rd February for campaigning. Hussain agreed that he will bear the expenses of police escort and that he would not visit his house, which is alleged to be the place where the criminal conspiracy was hatched, which falls outside the Mustafabad constituency. Hussain and the designated officers will be staying at a hotel room. Also, the court has restrained him from making any public comments regarding the merits of the matter and from meeting any witnesses. Next is an update on a matter related to Manipur violence. Kuki Organisation for Human Rights Trust today urged for an early hearing of the plea seeking a court-monitored investigation into certain leaked audio clips which allegedly implicate Manipur Chief Minister NB-DSA for instigating ethnic violence in the state. Advocate Prashant Bhushan, appearing for the organization, mentioned the matter before the bench of CJI Sanjeev Khanna, Justices Sanjay Kumar and KV Vishwanathan. Previously, Bhushan had submitted that the clips had disturbing conversations and the CM could be heard admitting that he instigated the violence and protected the attackers. Solicitor General Tushar Mehta and Attorney General R. Venkataramani had strongly objected to the plea. Today, Bhushan informed the bench that as per the last order, the bench had directed him to produce materials indicating the authenticity of the audio clips. Considering the same, he said that he sent the audio clips to Truth Labs for verification and had received a detailed report which has been filed along with the petition. The CJI today asked him to move a written request and assured that the hearing would be fixed as per the procedure. In another update, the News Broadcasting Digital Standards Authority or the NB-DSA has directed News18 India to remove a portion of its show Goonj with Rubika aired on March 28, 2024. The order came after the show attributed guilt to former Delhi Chief Minister Arvind Kejriwal in the excise case, which is still under trial, violating the Code of Ethics and Broadcasting Standards. The complainant here had claimed that the show concerned the arrest of former Delhi Chief Minister Arvind Kejriwal, which took place while the elections were underway. He submitted that while the anchor and the panelists were discussing the arrest of the Chief Minister, one of the panelists, a BJP spokesperson, alleged that the Chief Minister had actually committed a scam. This accusation was subsequently repeated by the anchor throughout the broadcast when she said that if such corruption had not taken place, then such charges would not have been framed, implying guilt and conviction in a matter under trial. The complainant further stated that a more concerning aspect of the broadcast was the anchor's attack on freedom of speech and expression and freedom of criticism. That she went on a monologue yelling at the panelists, saying that they could not criticize the Prime Minister and that calling the Prime Minister a corrupt man or accusing him of corruption was objectionable. After producing the broadcast, the NB-DSA, headed by its chairperson, retired Supreme Court Judge Justice A.K. Sikri, found a violation of the Code of Conduct in the broadcast. It held there was no problem with the anchor defending the Prime Minister in the broadcast. However, the problem lay in the manner in which the anchor had attributed guilt in a matter that is sub judice. It has held the same to be violative of not only the specific guidelines for reporting court proceedings or Code of Ethics and Broadcasting Standards, but also the judgment of the Bombay High Court in Nilesh Navlakha versus Union of India. Therefore, News18 India has been asked to remove the portion. The Union government has told the Supreme Court that there is no proposal to bring a separate law on bail as the provisions of Bharatiya Nagrik Suraksha Sanhita 2023 are adequate. The Supreme Court in the year 2022, in a judgment in Satyendra Kumar Antil versus CBI, had recommended to the Union government to bring a separate bail act to streamline the grant of bail. It had mentioned that United Kingdom has a bail act which was a comprehensive law dealing with bails by following a simple procedure. The UK Bail Act took into consideration the clogging of prisons with under-trial prisoners, cases involving issuance of warrants, granting of bail both before and after conviction, the exercise of power by investigating agency and the court, violation of bail conditions, execution of bond and sureties on unaccessible principle of presumption and the right to get bail. The court had opined that there was a pressing need for a similar enactment in our country as well. Last year, the top court had asked the union to inform if a separate bail law was under contemplation. Now, in the affidavit filed by Ministry of Home Affairs in response to the court's queries, the union government has said that the new criminal law BNSS, which replaced the Code of Criminal Procedure with effect from July 2024, deals with bail and bail bonds in Chapter 35. The union also informed the court that it has issued detailed guidelines and standard operating procedure for implementation of the Support to Poor Prisoners scheme, which were communicated to the states in June 2023. The states and union territories were advised to constitute an empowered committee in each district of the state or union territory and an oversight committee at the state headquarter level. A Delhi court has directed registration of an FIR against journalist Rana Ayyub after a complaint accused her of insulting Hindu deities and promoting anti-India sentiment through her posts on social media platform X. The complaint was filed in November 2023 by lawyer Amita Sachdeva via National Cybercrime Reporting Portal. Amita had alleged that Ayyub consistently used her social media posts to insult Hindu deities, malign India's unity, and promote hostility towards Indian citizens and the Indian Army. Sachdeva claimed that despite follow-ups, no action was taken on her complaint, prompting her to file an application under Section 156, subsection 3 of CRPC to seek judicial intervention. Chief Judicial Magistrate Himanshu Raman Singh of Saket Courts observed that a prima facie case is made out under Sections 153A, 295A and 505 of the IPC, which basically relate to promoting enmity between different groups and statements conducing public mischief. In view of the facts and circumstances, the court said that the complaint discloses commission of a cognizable offence for which an FIR is warranted. In the next update, the Telangana High Court has issued a significant interim direction prohibiting children below 16 years from entering movie theatres or multiplexes after 11 p.m. Justice B. Vijay Sen Reddy, while hearing a writ petition, instructed the Principal Secretary, Home Department, to consult stakeholders and issue necessary guidelines to regulate the entry of minors during late-night shows. This directive was passed in response to a petition challenging the authorities' decision to permit benefit shows and increased ticket prices for the movie Game Changer. The petitioner also highlighted the lack of regulation in such screenings, emphasizing that children's attendance at late-night shows should be strictly monitored. Previously, Justice Reddy had criticized the state for allowing benefit shows as early as 2 a.m., citing the tragic Pushpa 2 stampede incident that resulted in the death of a mother and injuries to her son. In light of this, the state assured the court that no further benefit shows would be allowed without considering public interest, health and safety. Justice Reddy stated that children below 16 years should not be allowed to attend screenings after 11 p.m., citing the importance of their health and safety. Until the state issues a final decision, this restriction will remain in effect. And lastly, the Supreme Court bench of Justices J.B. Pardewala and R. Madhavan has dismissed Advocate Vishal Tiwari's challenge to an order passed by the Registrar of the Court, who refused to register his application for direction to SEBI to file its investigation report in the Hindenburg Research Adani Group matter. Let me help you recall the matter here. Last year in January, while refusing to order SIT or CBI investigation into the allegations leveled in the Hindenburg Research report regarding stock price manipulations by Adani Group of companies, the Supreme Court had directed SEBI to conclude the ongoing investigations preferably within 3 months. Few months later in June, Advocate Tiwari, who was one of the petitioners in the matter, filed an application seeking a direction to SEBI to complete the investigations as per the timeline mentioned in the January judgment. Then in August, the Supreme Court Registrar refused to register the application, saying that the Supreme Court had not set any definite deadline for SEBI as per its January judgment, and that the court only said that the investigation should be preferably completed within 3 months. Regarding the other relief sought by Tiwari, that Union and SEBI should submit a status report on the acceptance of recommendations of the expert committee on strengthening the stock market regulations, the registrar had stated that the court had not directed submission of such a status report. The registrar also mentioned that review petition filed against January judgment had also been dismissed. Challenging the registrar's refusal to receive the application, Tiwari filed this application. He referred to the Hindenburg report, which challenged that SEBI chairperson and her spouse had investments in offshore funds linked to Adani companies. Contending that the report created an atmosphere of doubt, Tiwari said that it became incumbent for SEBI to conclude the pending investigations and declare the conclusion of the investigations. But the Supreme Court today passed the order rejecting the miscellaneous application filed by Tiwari.